Hamish, this is Stan, and this is Civil Banter. We're two lawyers at Nelligan Law helping people through injuries, insurance fights, and navigating life's legal curveballs. Okay, so we're going to get straight into our first segment, which is our frequently asked and answered questions. In this segment, we'll be answering all of those questions that you've been too afraid to ask your lawyer. So I'm going to go straight into my first question to you, Stan. Is what I tell my lawyer private?
Yeah, almost always. So solicitor-client privilege is pretty sacrosanct when it comes to our professional obligations. I will say there are some circumstances where that privilege does not always keep the communications private, but as a baseline, you can basically assume that what you're saying is going to be kept private, except for some very, very specific scenarios.
Yeah.
And it's actually a part of our rules of professional conduct as lawyers. So that client confidentiality is enshrined in the rules that govern us. There are, like I said, very few circumstances where that can get waived. One of them is obviously where the client instructs you as the lawyer to waive that privilege,
Right.
because the privilege exists for the client's benefit,
Yeah.
not for the lawyer's benefit.
You hold it
Yes,
as a client.
that's right. And so you're in charge of whether you waive it or not. The lawyer is not. If you're the client and you say, okay, you can share this information, then it can be shared. So that's an obvious one. A second one is if it's ordered by a court or a tribunal of competent jurisdiction. We won't get into what those would be, but basically, if it's ordered by a judge to waive that privilege, then it will be waived. But no more than was ordered, and no more than is needed to comply with that order. It's also waived if it's been required by the law society. So the governing body does maintain ultimate carriage, I guess, over that. And then there's some other scenarios which are discussed a little bit later on in the rule about permitted disclosure. One thing that I think clients should be aware of. We don't really run into this in our line of work as civil litigators rather than criminal litigators, but a lawyer may, doesn't say must, the rules say a lawyer may disclose confidential information, but not more than is necessary where the lawyer believes on reasonable grounds that there's an imminent risk of death or serious bodily harm and that the disclosure is necessary to prevent the death or harm. So, certain circumstances, I'm talking as the lawyer now, if your client is expressing that they may harm themselves if they're suicidal and you genuinely believe that that is the situation, then my interpretation of this rule is that you may use what they've told you, which would otherwise be privileged,
Mm-hmm.
confidential, to alert the correct emergency personnel, medical authorities to intervene to save that person's life.
Mm-hmm.
And so we're still human at the end of the day. Some of you might not think we are, but we are. And I would imagine most, if not all lawyers faced with that set of
Yeah.
circumstances would intervene and deal with the consequences later if that person didn't want their information shared. But you have to genuinely believe that there's some serious bodily harm or death that might occur if you don't act.
So there you go. Absolute with caveats, but
Always,
almost.
always with caveats with
Yeah.
us. It depends is remains the answer, but you can be pretty assured that a lawyer takes that ethical responsibility very seriously, that they're all aware of whose privilege it is, and that they're also aware of the circumstances where it can be pierced. So, Hamish, time for you to answer a question. Is there a maximum amount of money that I can, if I'm a client and I come to you and I say, I want to start a lawsuit, is there a monetary limit on that?
No.
Oh,
Well, no with caveats. I mean, in principle, no. The obvious being, well, you still have to prove what you're entitled to, so subject to evidentiary issues and what case you can put forward, then there's no necessary absolute limit. But there are restrictions, and then there are also different tracks in terms of different quantums of cases. So, small claims court back in October the threshold in which you can go to small claims court to sue was raised to $50,000. So that's an absolute cap on at least damages. There's still amounts for costs,
Disbursements.
taxes, disbursements, but the threshold for damages in small claims court is now $50,000, which is pretty considerable. Simplified procedure is closer to a regular lawsuit by a long margin, but is technically the next threshold in Ontario, at least in terms of claims. And in simplified procedure, you can claim up to $200,000 per plaintiff. So what that means is it's $200,000 in damages. You would also get an amount, or you could also claim an amount for costs and disbursement, which are also capped, which I won't go into right now.
Yeah, we could do an episode on simplified probably.
We'll probably need to at some point, but that's $200,000 per plaintiff. So if you have 3 plaintiffs, then you could be in simplified procedure. The maximum recovery in terms of damages would be $600,000 in that case. And then the ordinary procedure, aka not simplified procedure, not small
Everything
claims
else.
court, everything else, then there's no upper limit technically on what you can claim in a lawsuit, unless you're claiming things that are statutory in nature or bound by case law, because we still have to look at the case law. So the cap that we deal with most often is the cap on general damages, and general damages for pain and suffering we discussed in an earlier episode, you'll remember, but the cap was set back in, I believe, 1978.
I believe
Uh,
so.
and it was $100,000 at that time. And then so the effective cap on pain and suffering today is $100,000 brought into $2025, which works out to in the neighborhood of $440,000. So is there a maximum amount I can sue for? No, but also it depends.
Right.
Sometimes yes.
Yeah. Well, there's certainly maximums on your recovery, but there's no maximum on the amount claimed.
Yeah.
Yeah.
Okay. So we're going to be those people, and we're going to go into the topic of the episode, which is AI. It's everywhere right now, so it's something I'm pretty interested in.
I'm not.
I get riled up about.
I don't. I've been dragged here against my will. Absolutely have.
Kicking and screaming. So the first thing we're going to discuss is something that I think gets mentioned a lot in the context of AI in the legal industry, the legal realm, and I think it's overblown. Uh, we've both read, or we've at least both skimmed the recent cases. There've been a number of them involving basically the use of AI in mostly in factums and coming up with citations or pointing to case law which may or may not exist. So this is the topic of AI hallucinations.
Yeah. So we recently attended the CCLA Civil Litigation Conference, which was held in November. And it's a really great conference for those who are practicing in the world of civil litigation. One of the topics that came up on the judges panel was the prevalence of AI and its role in submissions that they receive and factums and oral argument, and how people have relied on it, and is it causing problems? And the short answer is yes, it is causing problems. I think if we look at how many cases there are versus how many cases AI has played a role in, it's a very small number, it seems, and they're probably being blown somewhat out of proportion. I say this as a skeptic of AI, and so I think you can take that for even more than what you would normally be said. But there are several cases where not just self-represented parties, but lawyers have used programs like ChatGPT or other AI programs and said, draft me a factum or do some research. And the AI, it seems, has created fake cases as precedents and cited those in the draft materials it prepares for these lawyers or these self represented parties.
It's a people pleaser.
I guess it
Hey,
is.
you want a case that says this? I'll give you a case that says exactly what you wanted to say.
And that I mean, there's my skepticism, which is well founded beforehand. But yeah, it totally makes up cases, and then I guess there isn't enough due diligence being done by the self-represented plaintiffs or defendants, self-represented parties, or the lawyers, and they're submitting these materials, and then the opposing counsel is going and clicking on it and trying to find out where it leads, and it leads sometimes nowhere, or sometimes it leads to a hyperlinked case that isn't the case that it says it is and doesn't stand for the principle that it says it stands for. And so this is happening. It's not happening a lot, but it is happening. And I think the legal world is adapting, and maybe you can talk about some of the adaptations that are on their way or
Yeah,
already in place.
yeah. So, and one of the applications of this, at least when it gets talked about and when it gets mentioned in these decisions, is again it comes down to like the cases primarily in terms of the AI is making up a case or a principle that does not actually exist or is not real or is not findable. So in the rules of civil procedure, I I think it would have been in the past 12 months. No, maybe it was a bit older than that actually. But anyway, in the past year and a half, the rules of civil procedure are amended so that when you're doing your factum, you as a lawyer, you have to basically certify that like, hey, I've read the cases, they are real. Like the cases are what they said they are. I checked the citations. These are cases that are real, which
Things you don't think you should have to do.
yeah, and which I think, I mean, good.
Good, I guess. I mean, you should have been doing that beforehand,
Right.
but here we are.
And I suppose my concern with all of this is that I totally get when it's a self-represented party that AI presents new risks in terms of, a self-represented party isn't going to consider themselves bound by the rules or the ethical duties or the responsibility in the same way as a lawyer.
They're definitely not.
They're definitely not. But realistically, is AI creating a qualitatively new problem? I would say no. I mean, a lawyer could have always made up a false citation at any point in time over the past 100 years of legal practice, perhaps even more so before we had Canly and online databases. You could misstate a case. You could say the case means X, but really it means Y, and things can get pretty gray because it is going to be a matter of interpretation. Some people say, well, this is obviously not what this case is about, and you could say, well, here's a reason why it is. The
Right,
case is about that. So, you know, I think I suppose where the issue comes from is in terms of the not knowing. If it's an unscrupulous lawyer who's just going to make stuff up, that's a problem that, you know, in principle has always existed. And if they're going to take work from their student or an articling student or a junior associate and they're just not going to review it, they're going to send it out without reviewing it, then that was an issue before AI existed, and it's an issue now as well, and nothing's really changed. I suppose the difference here is that there's maybe more of a propensity to inadvertently, uh, use AI and inadvertently mislead versus sort of more knowingly mislead.
yeah, there's definitely cases of inadvertence where, like you said, they just plug it in and it generates something, and then it isn't being reviewed and checked and verified that those things are true. There's a rather scathing decision. I'm not going to name the decision. Everybody in the legal community, I think, could find it relatively quickly, and it's sort of an ongoing matter anyway. Um, and it's an Ontario situation, but where a lawyer was and is in the process of being severely chastised for their use of AI in drafting a factum that created phantom cases, then arguing in front of the judge that those were real cases, and then in the face of being confronted with this, doubled down and said it wasn't them and that somebody else did it, drafted the materials and they hadn't checked them. And then eventually, when the investigation carried on finally admitted.
Eventually, they stopped digging.
Yes, they stopped and eventually said, "No, I did it. I didn't check it." And so, um, that's a really unfortunate situation. I think it can act as a learning opportunity for a lot of people who may be tempted by time pressures or time constraints, or maybe practicing an area they're not familiar with, to rely on a tool that's new and exciting and could possibly cut down on legal bills and promote access to justice. But at the end of the day, you still have to check these things.
Right. And, from I do I do think that when these cases, obviously the case on its merits is important and needs to come out. Like this is a real issue. I find that when these cases get discussed at conferences, it's shining a spotlight on an issue where it suggests that that in principle we should be using AI for legal research. And I think the answer is, if you've used AI, you will be able to tell it's actually not that good at legal research,
Uh,
and it's not like a strength of it. And if you're using AI effectively, which I think you certainly can do in legal practice, you should be turning its attention elsewhere, and using it as a drafting aid, not just turning your lawyer brain off and just outsourcing it to AI.
Totally. So, as a skeptic, I ran the case through it
Hmm.
from the episode we just recorded, the one that came out before this one. And I said, summarize this case, having read it a couple of times. And it initially spit out something in, like, I don't know, 5 seconds. I was, floored by how quickly it happened. And it looked pretty good. It had bullet points and
Hmm.
headers and like sub points off of that. It said things like facts and issue, and it sort of looked like a legal memo would look. And at first glance, I can absolutely see how somebody using AI would think, awesome, like all my problems are solved. Look at this case summary. Things are great. And I read through it, and it misses a lot of really important stuff. It misses things that we, as, trained lawyers who know what the issues are, know what will resonate, and know what the important facts are in the context of the case you're looking at, it'll just skip those entirely. So it didn't refer to the fact that the plaintiff in the case we discussed previously, Miss Bernier, that she had done the race the year before on numerous occasions, previously signed the waiver. It just didn't. It just, in its quick 5-second analysis of the important facts, didn't think that that was one of the important facts.
Yeah. So I think and my example is, I had a client send me something that was clearly generated by AI, and it's weird. It was like accurate, it was good, but it missed the key point. So he'd had it summarize an insurance policy, and sent me what it said the insurance policy's terms were in a given fact scenario, and everything everything it summarized was accurate, but it missed the key issue. Like, it missed the only issue that mattered in this factual dispute. So everything was, they're all like, well, this is a true statement about the policy. This is another true statement about the policy. This is also a true, succinct statement about the policy, but none of these are the issue in your case. And so I think that's it. It's a tool. Um, if you ask it a one sentence prompt, yeah, I mean, it's going to treat you like you're a one sentence prompt type of guy, you
Oh,
know?
okay. So
So
user error on my end, because
it,
that's literally all I asked it to do. I just said summarize this case, and so
now,
it's possible I'm not using it properly.
if you gave it 4 paragraphs of instructions, and then based on its result, you gave it another 4 paragraphs of instructions, and then based on its answer, you gave it another 4
See,
paragraphs of
at this point,
instructions.
I'm just writing my own my own memo. If I have to give it 2.5 pages of instructions and refine it over the course of an hour and a half, I might as well have just read the case and done it myself,
Now
right?
that is an interesting, but I'm imagining, if you're a sole practitioner, I mean, I can just only imagine what it potentially opens up. Um, but in terms of the court's guidance, it's basically do what we are always hoped and you were always obliged to do, but you're now certifying it. I think that's a good step, especially because it's highlighting the key issue of checking that your citations are correct and true. Now, I read a practice direction that came out from the federal court, which is not where we practice. We practice in provincial court in Ontario, but lots of different courts have their own practice directions on how to approach certain things. And they are, I mean, they're more than that. Practice direction makes it sound like
Yeah.
it's just a suggestion.
No, they're
It's really not.
rules.
Yeah, they're rules.
Yeah.
But in federal court, if you use AI in the preparation of a factum, point blank, you have to make a statement to that effect that you have used AI in the preparation of a factum. Now, I think especially in the early days, I think the issue is you make that statement and you are, I think, probably putting yourself perhaps under a bit of a microscope from opposing counsel and perhaps from the bench in terms of what's in your factum. And I don't think that's necessarily fair or proper because I don't have to disclose any other tool I use in my practice. I don't have to say I used Westlaw, I used spell check, I used a fax machine, I used Microsoft Word, I
Right.
used Adobe. Like I don't have to disclose what tools I use in the preparation of my factum. So I don't understand why I then have to be like, well, I'm using AI as a tool, like any other tool. Why do I have to advise and put myself under the microscope that I've used AI in some part, in any part of a factum? It could have been no matter how small. What if on one sentence I said, I don't like the flow of this sentence. Can you give me three other suggestions of how this sentence grammatically flows? And now I have to certify that I've used AI in the factum.
Yeah. I wonder what we don't really know what the inside thinking was on that one, but maybe it's along the lines of just making sure that if you're signing off on that, that you're reading your cases and it's sort of holding you to account,
Right.
maybe more than it is anything else. But
And yeah, and accountability is good. Now eventually we will come to a point where if you have not put that certification on your factum, it's going to be like you didn't use what do you mean you didn't use AI on your factum? Like we are going to get to that place given that AI now is the worst it's ever going to be. I think in 5 years time if you're submitting a factum and you're not putting the statement that you used AI on your factum, I think that's going to be an issue.
I'll be there with the dinosaurs, maybe. I don't know. Who knows? I could be changed, but it's uh, it's tough, I think.
Anyway.
Well, I will say this, another criticism I have of AI. So I had to replace a headlight on my car, and I'm
Hmm.
I'm not handy at all, but I'm becoming handier by looking things up on YouTube videos and so forth. Anyway, I went to the Canadian Tire. I asked the guy, like, this is what I think the headlight is. Is this the right one? And he punched it into their system and said that it was. It didn't really work right. I hadn't installed it properly. I went back and I said, it's not really working properly. Are we sure? And Googled it, and the Google AI summary was totally wrong.
Oh.
And he said, like, don't pay attention to the Google AI summary. It's not usually right. And lo and behold, it wasn't. We had checked it. It was the correct headlight. I hadn't installed it properly. I went back and did it the right way. But there's another example. Something you think is like pretty easy to get right,
Yeah.
but it didn't. So
So what you're saying is you now have a personal animus against AI. I will beat it.
yeah, that's right. Yes. Yeah.
Okay, well, I could talk about this all day, but instead, I'd suggest that maybe you go on my LinkedIn because I'm going to start posting about this more because I think there's a lot of meat to this bone. So we'll say our goodbyes, and if you want to peruse my LinkedIn for any insightful AI posts, I'll be posting a lot in the new year on this topic at linkedin.com/in/hmillsmcEwen. Stan, where are you on LinkedIn?
LinkedIn.com/in/Stanford Cummings.
And if you like this topic or have topic suggestions or ideas, or just general ideas or suggestions in terms of format, if you like more case based or more issue based or more banter, less civil, then let us know. You can reach us at civilbanter@nelliganlaw.ca.
Like, comment, subscribe.
Okay, that's a wrap. Goodbye.
That's it.